another inquiry, and there might be various grounds that a state applying federal issue preclusion rules, as the state court would do, that a state could, so that preclusion would not inevitably apply in that case.
Let me pick up on that. In order for you to win, would it not be necessary for us to backtrack on a number of things that the court said in Heck? The court said that the district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction or sentence. If it would, the complaint must be dismissed unless the plaintiff can demonstrate that the conviction or sentence has already been invalidated. Now, is your position consistent with that?
Absolutely, Justice Alito. In fact, we think that this case comes within
How can it be consistent with that if someone is convicted under a statute and then brings a 1983 claim for prospective relief seeking to have that statute declared unconstitutional? A ruling in that plaintiff's favor in the 1983 action certainly implies the invalidity of the prior conviction, does it not?
Your Honor, we don't think so, and let me offer two reasons why not. And let me begin, as Your Honor did, with Heck itself. After setting out the necessarily implies test on page 487, on page 488, Justice Scalia rejected a broader rule which would bar Section 1983 suits when they would resolve a necessary element to a likely challenge to a conviction, even if the Section 1983 court need not determine that the conviction is invalid.
Well,
and the element here is the law's unconstitutionality, and that's all the Section 1983
Let me make
suit
it more
involve.
concrete to pick up on the situation that Justice Gorsuch was positing. Let's say that a defendant is convicted for a defendant who has a prior conviction for a nonviolent offense is convicted for possession of a firearm by a convicted felon. And let's suppose that that individual then brings a 1983 claim seeking to have the statute declared unconstitutional insofar as it applies to someone like him with a prior conviction for a nonviolent felony. Would that not, and let's suppose he wins on that, and then he is, meanwhile, he's charged once again with possession of a firearm by a convicted felon. Doesn't that invalidate that prosecution?
No, Your Honor, because I think the key is what is the relief that the individual is seeking. So if you're seeking prospective relief that you cannot be prosecuted under a law going forward, that is a set of facts in the future. What Heck protects is anything looking back to the set of facts in the past, and it protects that conviction. It protects individual convictions, not the criminal law in the abstract, Your Honor.
On your question 2, footnote 10 of Heck says, the principle barring collateral attacks, a longstanding and deeply rooted feature of both the common law and our own jurisprudence, is not rendered inapplicable by the fortuity that a convicted criminal is no longer incarcerated. So we would have to abandon that, would we not, in order to rule in your favor on question 2?
I don't believe so. If the court did need to reach question 2, which we don't believe it does, I think this court, in another footnote in Muhammad versus Close, indicated that that issue was still open. So we believe that issue remains open for this court to resolve.